And you're watching Book TV on C-SPAN 2. We are on location at the Georgetown University School of Law here in Washington, D.C., where we're interviewing professors who are also authors. Joining us now is Professor Robin West. Her book, Teaching Law, Justice, Politics, and the Demands of Professionalism. Here is the cover. Professor West, what does it cost to go to law school today?
Oh my Lord, it costs, let's see, somewhere between $120,000 to $200,000. Many of the students graduate with just that amount of debt or more once you figure in the cost of living. It can be a significant financial investment to go to law school. Not all law schools are that expensive, of course.
Is it worth it?
Oh, I believe it is. I believe it is. However, it's clearly the case that law schools are graduating too many lawyers, too many JD graduates. We have, over the last few years, graduated somewhere around double the number of law graduates as there are law jobs that the economy can absorb. And this has created a serious crisis of underemployment and unemployment for our recent law graduates, many of whom are now competing with lawyers who've been squeezed out of big firms or who have been unemployed for the last 2 or 3 or 4 years. This is the biggest crisis facing law schools right now. Is simply the number of graduates who have finished law school, who are on the market, but who are unable to find legal jobs.
Is the way law school teaching is structured, is it the correct way in your view?
I think that the problem is not that that we're teaching law school in a terrible bad way. I think it's inadequate and insufficient for some purposes, and I suggest a number of reforms in the book. But I don't think the problem is with the basic structure of law school. The problem, again, is simply that there are too many law schools graduating too many people into a market that has become saturated. We need to cut way back on the number of people who are attending and then graduating from law school. That's the basic financial crisis that law schools are facing.
If we cut back on the number of people graduating from law school, will that create a shortage for people who need lawyers?
Well, in some ways, there's already a shortage for people who need lawyers. The middle class, and particularly the sort of lower ends of the middle class, do have problems finding lawyers that they can afford to pay. People who have too much money to qualify for legal aid, but who are not sufficiently wealthy to pay top dollar for top lawyers, can have trouble right now finding lawyers. And so in some ways, the problem is a mismatch in the market between middle-class people who need lawyers for ordinary events in a lifetime, writing a will, closing a housing sale, getting a divorce, negotiating a custody agreement with a warring spouse for the care of your children, etc. These are ordinary legal events that people in all economic spheres of life face, and many people have trouble finding lawyers to meet those needs. So the problem is not simply that there's an overabundance of lawyers, it's that we're graduating too many people who cannot simply move into pre-existing jobs, but who also cannot put together the resources and the skills necessary to go into a ordinary solo practice so as to service the needs of middle-class people who can't afford law firm prices. That's the overarching problem.
Is there a disconnect between legal scholarship and the practice of law?
There's certainly a disconnect as felt by the practicing bar. Judges and lawyers increasingly say that legal scholarship is not serving the ends of professionalism and not serving the ends of the legal profession. I'm not sure that's a problem. I don't know that it should be the goal of legal scholars or of legal scholarship to meet the immediate ends of professionals. To my mind, what legal scholars should be doing is taking a detached view of the law, of legal institutions, and of the legal profession itself, and subjecting it to rigorous inquiry. They should do so toward the end of trying to critique laws so as to further the ends of justice, asking questions about to what extent the laws that we have today actually do serve the ends of justice. And they should do so toward the end of increasing our societal knowledge about the legal system. They should, in other words, a scholar should, in other words, use scholarship so as to further both the end of justice and the end of knowledge or the end of truth. That's the traditional goal of the academy in which law schools today are situated. Sometimes that scholarship will be of use to the practicing bar and to the bench, but sometimes it won't be. Sometimes the goals are more far-sighted than that.
Now, you're a law professor. What do you teach here at Georgetown?
I teach contracts sometimes, I teach torts sometimes, and I teach a number of seminars such as law and humanities, law and literature, and jurisprudence seminars.
Have you practiced law?
I practiced very briefly after I graduated. Yes.
And why just briefly?
Oh, I knew halfway through law school that I wanted to teach. I did not go to law school with that goal in mind. I think it's still the case that most law students go to law schools intending to be lawyers, not intending to be law professors. And so, like most of my peers, I decided on law teaching about halfway through law school.
If you went out into the marketplace today, would you feel qualified to practice law?
No, I would not.
Why?
Oh, because I have not studied law with that goal in mind for many years, and I have not maintained skills with that goal in mind for many years. No, I am a legal academic, for better or for worse. I feel quite comfortable in that role. I don't think that these roles are easily interchangeable. Not for most people. For many people they are. I have a number of colleagues here at Georgetown, but a number of colleagues throughout the country who combine law teaching and legal scholarship and legal study with some sort of legal practice, usually appellate practice. But that's not the norm. The norm today really is a legal academic who is simply a scholar and a teacher.
What's appellate practice?
Arguing cases in front of appellate courts rather than in front of trial courts.
Do you think it's necessary for you to know how to practice law as a law scholar?
No, I think that law scholars have different areas of expertise. Law scholars should be masters of some aspect of the law, not necessarily some aspect of legal practice. There are a number of law scholars, of course, who are masters of some aspect of legal practice, and there's a profound need for those people, I think, in the legal academy. But I think it would be a shame if law schools took such a pivot toward creating what are now called practice-ready lawyers, that the entire academy became, in effect, a vehicle for facilitating apprenticeships in law. That's not what law schools and what the legal academy has been for about the last 100 years, and it's not what it's set up to do. We would lose an awful lot of value if law schools abandoned their now traditional role of examining and criticizing law and legal institutions and the legal profession itself, and instead refashioned itself toward the end of simply preparing law students to be practice ready. There would be tremendous opportunity costs in doing that.
What's one of the cases that you like to go to when teaching class?
Oh, the cases that I most enjoy are the canonical first-year common law cases. I just think there's nothing more fun than teaching cases like Hadley v. Baxendale
And what case
or
is
Hawkins
that?
v. McGee.
What are those cases?
Oh, these are cases that you may recall. Did you go to law school?
I did not.
Oh, then you won't recall. Well, many contracts courses start out with a canonical case about a father and his son in the early part of the 20th century suing their family doctor. The son had had an industrial farm accident and had seriously injured his hand. The only remaining injury, though, was cosmetic. It looked somewhat deformed. A surgeon promised the father and the son that the surgeon could make the hand whole. The surgeon then proceeded to do the operation, and the hand came out much worse than it had been prior to the operation. And so the father and the son sued the surgeon for breach of that promise to make the hand whole. And the court had to grapple with the question whether the promise that the doctor had made was enough like the kind of promises made in commercial contexts so as to warrant the use of a measure of damages that's really more appropriate for purely commercial contexts. And the court decided that it was indeed enough like a promise, like a guarantee or a warranty, that say a machine part would be well functioning to permit a measure of damage